Competence to consent to a search and seizure. This is for advanced forensic psychology and spring of 2024. Optional media. Who can consent to search? From Federal Law Enforcement Training Center's Chief Bezelman discusses with the senior instructor Miller about circumstances regarding consent to search, particularly in the case that two people have occupancy of a residence while one person consents and the other doesn't. In this example, a married couple in a custody dispute is used. I've provided the link in the slide here. I'll also be posting this to the YouTube description as well as the Canvas submission. Sorry, give me 1 second. Competence to consent. An unreasonable time to request can point to coercion. Mistreating a person beforehand could lead to a less voluntary consent. Per state laws, intoxication must be considered, as well as if it is voluntary or involuntary intoxication. Consent may be invalid if the person consenting is sleeping, sedated, or suffering from physical trauma. The Closing the Law Enforcement Consent Loophole Act of 2022 prohibits federal law enforcement officers from knowingly having sexual contact with people in custody, detention, or under supervision. The Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Seizure of a person. The officer must make clear to the person in question that they are a police presence that cannot be ignored via the following: having weapons and handcuffs visible, speaking in an authoritarian voice, and using physical contact as needed. The person being seized must submit to authority. The 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This section of the amendment is the only one of the 5 sections that pertains to search and seizure. Requirements for consent search. Consent must be voluntarily given. It cannot be valid if obtained by coercement, implicit or explicit means, or implied by threat or covert force. Validity of the consent is determined by a judge given the totality of circumstances, including the age of the person, their intelligence, and education level. Consent must be given by a person who has actual or apparent authority over the possession in question. For example, community property or in a vehicle search in which the owner of the vehicle is a passenger. Consenter's mental state. If an individual is found to have been impaired during the time of search due to their mental illness, the search will be found unlawful. maturity and sophistication, prior experience, and contact with law enforcement, and whether the searchee knew of his right to refuse the search at the time are additional factors that should be considered in the totality of circumstances. Since the case of Schneckloth in 1972, in which the courts determined that a person must be of sound mental state in order to give valid consent, the courts have used various methods to create a flimsy set of standards regarding mental state at the time of consent to search. It is also difficult, due to the subjective nature, to prove that an officer's behavior was coercive. During the course of a consent search of a car that had been stopped by officers for traffic violations, evidence was discovered that was used to convict respondent of unlawfully possessing a check. In a habeas corpus proceeding, the Court of Appeals reversing the district court held that the prosecution had failed to prove that consent to the search had been made with the understanding that it could be freely withheld. Discussion question. What is a specific example of a case you've encountered in your education, workplace, or have heard of that involved a search or seizure that was unlawful due to incompetence of the person in custody? Sources. Hernandez, the Department of Justice, La Cornell, Lemons, Rain, Schneckloth versus Bustamante, U.S. Constitution Amendment number 4, and the U.S. Constitution Amendment number 14.